Excellent. Okay, well, I'm just going to do a brief overview of intellectual property. I'm a patent attorney, which might sound like a lawyer. I'm not really a lawyer. I'm almost a lawyer. I specialise particularly in patents, but intellectual property more generally is kind of what we deal with. My background was in physics originally, so it's kind of applicable to the real world sometimes. There we go. Right, there we go. This is just a few details of the firm. Kilburn and Strode appears who I work for. For a patent firm, it's a reasonably large firm, but for a law firm, generally, that would be quite a small firm. But we specialise specifically in patents and trademarks. And just covering a few of the grounds that Adam mentioned earlier, intellectual property comes in various forms. This I've divided up here into kind of unregistered and registered rights. Unregistered rights being rights that. Unregistered rights being rights that arise automatically. You don't need to do anything. You have this right by virtue of the creation of your intellectual property. So copyright or unregistered designs, create those works, and you have that limited protection under the law. Know-how's the other one, which is confidential information. A good example in the talk earlier, Perpetuum know what these vibration signals mean, but they don't need to protect it in any other sense. They just keep it confidential. That gives them a commercial advantage over anything that anybody else does. Registered rights, trademarks, protect your brand name. Registered designs, which is a kind of more broad, definite protection of the aesthetic form of your product compared to an unregistered design, and of course patents. When we talk about patents particularly, because that's my area, patents are about protecting the substance of an invention, not the particular form of it. So, say your invention was carried out in software, you have copyright to that actual code. Any copying of that code is an infringement of that copyright. But a reverse engineering or a reworking of the code wouldn't necessarily infringe the copyright, but could infringe a patent if you had a patent to protect the underlying principles by which your invention worked. It's a right to exclude, which is to say, it's not a right to carry out something, as mentioned earlier. Even if you have a patent for your product, you may not be free to operate it if somebody else has a patent but also covers your area. A patent gives you the right to prevent others from doing it, or indeed to license them to do it, but it gives you control over whether others are able to carry out your invention. It lasts for a limited amount of time, and in return for getting that limited protection, for that limited monopoly power for those 20 years, you have to disclose the invention. Which again, this is a balance you may want to look at when we were talking about know-how, for example. Is it better to keep your invention confidential than to protect it via a patent? A patent and a confidential approach are necessarily exclusive. You cannot be confidential and be patented, so you have to choose one or the other. And the final point on this general slide is that your patent is a national right. You may have a patent in the UK, doesn't mean that you're protected in the US, doesn't mean that you're protected in China. It creates a minefield practically and in terms of cost when you want to take these rights outside of your home territory, when you want to file them in multiple countries. So that's something to bear in mind. And basically, also, the patent process is expensive. That's part of the reason why, but it's also worth thinking about, does a patent really fit in with what you want to do? Is a patent, does it fit with the business model that is suitable for your approach? A brief overview of what can you get a patent for? Well, you can get a patent for an invention as statutory invention, but it must be new compared with anything that's been disclosed anywhere by anyone, including yourself. So one of the pretty key points, if you're thinking about patent protection, is that you have to apply for your patent before you disclose the concept publicly. You can disclose the concept to others under non-disclosure agreements or in confidential circumstances, but if you're publishing a research paper that gives away the invention, after that you have limited opportunity at least to file for patent protection. You could perhaps, some countries there's a bit of a grace period. The basic principle is no, don't disclose your invention before you file the patent application if that's the route you want to go down. Inventive steps, very obviousness. The next stage is it can't just be different. It can't just be a red version of the thing that was blue before. If that creates no technical advantage, it's got to be a non-obvious solution to a technical problem. So it needs to create some advantage and do it in a way that wouldn't have been obvious if you were trying to fix that problem. And the last point on that slide is patentable subject matter. We'll talk more about that later. It's particularly computer programs. Are they or aren't they patentable? Are they the right subject matter for patents? The patent application process involves various stages. It's not as simple as simply just depositing your application at the patent office and then you've got a patent. You do have to do that. First, you've got to draft the patent. You've got to define what you want to protect. Because this is the challenge in some respects of the patent process. If we're trying to protect a concept, it's not a case of just reciting the specifics of what you do and protecting that. It's defining what makes your concept unique and what makes it inventive without too narrow defining that to specifics that people could work around if they want to copy your concept. So you've got to draft and file the application, but once it's filed, it needs to be examined by the patent office, who will come back and try and establish whether or not it's new and inventive. They'll look through their databases of documents, try and find reasons why you can't have this patent, and then you ultimately you have to convince them that you can define the claims in such a way that they're convinced that they're new and inventive, and get the patent granted. In the application itself, and this is a pretty good summary of the things you want to think about when you're thinking about whether a patent is the right place for you. We've got to have a background here. What's the issue? Why is it that what exists already doesn't solve this problem? Why is it that you can't just use existing technical solutions? You have a summary section here of the key. What is the insight we've gained that solved this problem? We have a detailed description. You need to have made one. You need to give a recipe for how I can go out and build something that implemented this concept. And then the claims, which, as I say, define the scope of protection. It tends to be quite a complicated legal phrase, but we try and establish the key elements of the invention in one sentence in order to capture what it is we're trying to protect, both to define what would be infringed by a patent if it was granted, and what we need to be the scope of what we're claiming is new and inventive in comparison with the prior. Skip one. International protection, as I mentioned, if you want to cover every country in the world, it's going to be expensive. You typically have to pick out some of the countries that matter to you. You don't necessarily have to do that on day one. On day one, you just tend to file in one country, you then have a year to claim priority from that first filing and file elsewhere in the world. There is a process, the Patent Cooperation Treaty, it's an international application you can file, which covers most places, and then you break down into a European application, and ultimately you have national patents granted at the end of the process. There's no point, I won't go into too much detail about that now. This is just a slide of some of the countries that you can get protected in Europe. So the European patent application procedure covers all of the countries in the EU, plus some others. These particular diagrams show various legal changes that might be coming into force in due course, but basically if the country is highlighted here, then it's part of the European patent application procedure. In the future, there may be a unitary European patent once granted, but at the present day, it breaks down into national patents in each of those countries. So, coming more to the subject that I think we've mentioned it earlier, we have this issue about whether you can patent a computer program. You can patent, first of all, you have protection under copyright for your code, because it's a creation of yours, you put in sufficient effort for it to be a copyrightable principle. But can you patent the underlying principles? And you may indeed not want to, you may not feel that that's right for the kind of, it may not, A, be appropriate for your business model, may not be appropriate for what you feel is the right way to address these kinds of issues if you prefer an open source approach to developing technology. If you're not going to patent it, you need to think about, well, how are we going to still make money out of it, even if some elements of our code at least are open source. Furthermore, we've got an issue in terms of what can you patent legally, what counts, what is considered a technical invention. When it's just implemented on a computer, when a computer just does something new, have you made an invention or have you just made a new computer program? And the law on this is opaque as ever. You can't patent, according to several of these, you can't. Programs for computers are not regarded as inventions, but only to the extent that such inventions relate to such subject matter or activities as such, which you might feel is a bit of a circular point. What are they trying to get at? In essence, I mean, actually, intelligent sensing is a really good example here. That very often your inventions will be implemented through software, but won't just create a software result. You're creating that kind of technical benefits. You're farming chickens better because you know what's going on. You're able to identify some aspect of the real-world environment and therefore change some real-world quality. It's not limited just to what's happening inside the computer. So it's not particularly clear though, how the law applies, which is why it's worth thinking about how can we do this, and how can we make it work, and how do we decide when patenting is the right approach for you and your invention. So you can't patent a program as such, but you can patent a computer-implemented invention. A patentable invention is technical, and it solves a technical problem. So there's some existing technical difficulty that you're overcoming. It's not a case of, for example, there was a case in the US recently, people trying to patent a method of hedging a financial transaction. So you make this transaction and then you make these other transactions to hedge the risk. There's no technical issue there, you've got a business issue there, you've got a business risk, you've not got a technical problem with that. But you may have a technical problem if your computer is slow or it's unable, or your network is unable to deal with some data and you've got some new way of managing it, handling it to improve the way the system works. So, but as I say on this slide, asking, does it solve a technical problem? It's just the same as asking, well, what does technical mean? And one way of looking at that, and one way of getting to the bottom of that, is to think about the other areas that aren't patentable, so other things that aren't technical. Might be discoveries, mathematical methods, methods for performing mental acts, methods for doing business, presentations of information. So these are all things that you can do in new ways that aren't per se technical. They don't have technical character. These things are excluded legally, in the statute. And we can kind of look at it and say that is a list of the kinds of things that we consider not to be technical. So you can't patent the discovery, but you can patent the application of it. And you can't patent a computer program, but you can patent an invention which uses the program to do something more above and beyond merely being a computer program. In practice, I think one of the elements I haven't mentioned here, but every patent office applies these rules slightly differently. Everywhere you need to have an invention, and technical is a good kind of proxy for what they will look at. You want to demonstrate that you're doing something physical or technical or out there in the real world to improve a process. But not every law is exactly the same. But here are just some examples. So in the UK, a UK patent office or the UK Intellectual Property Office will say if your invention doesn't solve a technical problem or doesn't make a technical contribution, it will be refused for being unpatentable. It's the wrong kind of subject matter. At the European Patent Office, it will be refused for lacking an inventive step because it doesn't solve a technical problem. It's the same result, but different approaches. Different patent offices will look at it in different ways. But at the heart of it, the key is to think, are we doing something technical? Are we making some jump with respect to prior art? And to try and illustrate that, I've got some examples here of some real cases that came up. Vicom was one of the kind of seminal cases back in the 70s or something. There was an image processing method, so it basically took data, improved the outcome, gave you a better image. All you were doing was handling the software elements, handling the data. You didn't actually have any physical element that you punched into shape. It was all on the computer. But because of the result being something that had some technical improvement, it was considered a clearer image is technically better than an unclear image, for example. That was considered to have some kind of element of physical reality that the application was allowed. That was considered, yes, that is a solution. The next example is the other way around. There was a method of calculating square roots, which obviously in a calculator, in a computer, that's a kind of classic challenge. How do you calculate a square root? This was a superior way, this is the answer. But essentially all it was a mathematical algorithm for calculating square root. It was argued that there was an increased benefit of speed, but at the end of the day, it was just considered, well, that is, you're simply trying to protect the mathematical concept of how a square root is calculated. And that, therefore, isn't a computer program, well, isn't technical, and therefore can't be protected. This more recent case was an improved method of handling dynamic linked libraries. So, in the operating system, you have various connecting files to enable things to speak to each other. There was a problem in the way that these were managed or indexed. I can't remember exactly the details there, but it slowed down the computer. It wasn't the most efficient way of running it. So to solve that, it was an improvement in the operating system, essentially. And again, this one felt, in some respects, very close to being an improvement in the operating system. That is just the way the computer works. So if anything is software, it's a computer operating system. But in this case, the patent was allowed on the basis that it makes a better computer. You've still got the outcome of a computer that works better than the computers that worked in the past. So you've made some kind of benefit outside of merely arbitrarily a new way of calculating something. You've actually made a physically better computer. It's a somewhat difficult case to reconcile with some others, in the case that any computer program makes a better computer, otherwise why did you write it, why did you put it on there? Here, I think the way it was seen was that, well, this being at the OS level, it's a general purpose computer which is improved rather than a computer program which is just better for the software application that it's written for, in which case that is just a software concept. Okay, and so the Apple case, this is one of the cases which is a bit more intuitive to feel. There was a patent granted for Apple's slide to unlock on your iPhone or your iPad or your iPod Touch, which did get granted at one stage on the basis that this is a new way of getting into the device. You can see a technical argument perhaps that previously you'd need a physical hold button to avoid you turning the device on accidentally, and this was an easier way to access it, but without the device turning on accidentally. It's still safe battery power, but it was more user-friendly or some respect like that. So they did get a patent to the concept of unlocking a device by moving an unlock image along a predefined display path. So to say, they argue that the problem solved, there was a technical issue, that the device without that would be unfriendly or awkward to handle, and that improved it. But in the end, when it went to court, because I think they may have tried to sue Samsung, probably, or somebody like that. The case ended up being invalidated for lack of inventive step. And that's simply because devices that were not too dissimilar actually already existed. When it got through the European Patent Office, the EPO, they hadn't found the prior art that was closest. But in actual fact, there were earlier mobile phones or similar devices. So.
And simply about the prior art, so does also the prior scientific papers count, or only patents count?
Everything counts, but in practical terms, the patent offices are better at searching earlier patents. They do try and search scientific papers, but they're not as good at searching it. So what you find is 99% of the time, what the patent office comes up with is an earlier patent. And it may be that you get a patent granted without then identifying what is the most relevant art, which might be a scientific paper, or it even could just be, you know, a publication on a website. Anything that was available to the public counts, but what's best searched is a practical issue.
And sorry,
yeah.
If the patent is proved and is accepted, and one say that, for instance, that the patent is already used for, but it's not patented actually. Is there any way to sue the company that patented the invention?
So sorry, if somebody tries to patent an invention that you've already been using.
For instance, yeah, I think that one person was the actual inventor, but for instance another company used that, for instance, scientific paper, and basically took the idea and patented the idea. So is there any way to solve this problem? So,
well, there's kind of two aspects to that kind of issue. So if we forget the scientific paper for a moment and say that was never in the public domain, but somebody took somebody else's invention and filed an application for it when they weren't entitled, your entitlement to the patent always comes ultimately from the inventor. So if you took an idea and illicitly filed your own application for it, there are actions you can take to correct that entitlement later. But in the specific circumstances you discuss, so for example, an individual publishes a paper, they have no intention of patenting it, but they publish that paper, and then somebody else tries to file a patent application for it. Whether they came up with it independently or they did copy it, that paper itself would be prior art against that patent, so it could potentially invalidate it. So there's either way, people who behave nefariously, as you described, shouldn't get away with it ultimately, but again, it's a matter of practical reality how quickly these issues get resolved. But yes, there are procedures in order. You shouldn't be able to get a patent for something that you don't have the right from, starting with the inventor. Here's a quick slide on some of the differences between the US and the European approaches. So it's a very, very historic, very generally, it's tended to be easier to get patents for software in the US than it is in Europe. There was a case, State Street Bank, where they said that anything under the sun made by man could be patented in the US. But actually more recently, they've drawn back a little bit from that and said, well, you can't patent abstract ideas, obviously, or you can't patent anything that preempts the application of an abstract idea. So it comes back to this idea of, you know, you need to have a real kind of more tangible concept. You cannot just patent something which is theoretical. It has to be practical. And so an application that would get through in Europe would almost certainly get through in the US. But sometimes, even if your advice is, well, we can't go ahead in Europe, there might be some value in trying to push it in the US. And this is just an example of a kind of software invention that I've worked with, a UK startup. Their technology was about online ad fraud. So ad fraud and also just ad metrics to work out has an advert that's on a web page being seen. So if I load up the Guardian front page, there's an advert halfway down on the right-hand side. Previously, you typically say, well, okay, if the Guardian front page has been loaded, that counts as a view. Or if there's a click on that advert, that counts as a click. But previous approaches haven't properly captured whether your browser window was actually over that part of the web page, whether you could actually see it. This technology, and there's various reasons why that was difficult to do practically, because of the way that adverts are delivered within iframes, it makes it harder for you to reach out and discover information about the page as a whole. So this is very much a software application, but it allowed you to discover some kind of technical aspect of what was going on in the system. They filed a few applications in the US, particularly, we kind of emphasised, and they in the end were acquired by Google and have made it up into the sun. They're working for Google now, and obviously the patent application supported their business model and got them to the place they are today. So it is possible to use patents with a software invention to make a business succeed. And that's the end of what I've got to speak about. If anybody has any questions, I'd be happy to ask those. Yeah.
So you always hear these horror stories in the US about patent frauds, but you really don't hear much here in the UK. Is that because the landscape is much better here, or is it because it's not as public as in the
It happens everywhere. The reason why you hear more about it in the US is there are a few reasons. Just practically, a single court case in the US covers the whole of the US. The European market's still fragmented, so you still have to litigate in the UK and in Germany and in the Netherlands and in France and so forth. So if you want one big win, the US is the place to go. Often, and so it's the single biggest market. Often the companies involved have some kind of US bent anyway. Obviously, in the mobile phone wars, not so much necessarily. Also, there's a bias in the US, a stronger bias towards considering a patent that has been granted by the Patent Office to be valid. Here, it goes to court, and the courts will look at it again as if no decision had ever been made and just look at it on the merits. In the US, they tend to make a presumption that anything that was granted was valid. So the patentee's position, the person holding the patent, is stronger in the US, which is often why they will start in the US when they're trying to raise revenue without actually making products.
So the situation is much better in the UK than
It's not as clogged up at the moment, but it's due to no particular virtue of the European system, I'd say. It's just kind of, it's a combination of practical factors, but it's not something that can't be done in Europe. In fact, there are plenty of people who do try and run a similar business model in Europe. It's just not as big news when it goes to court.
Okay, last question.
Okay, sorry.
So there was, in the beginning, there was a slide saying that you can patent your idea, but you have, you have to disclose it openly for 20, but you have exclusivity for 20 years.
Yes.
And the other option is to keep it confidential, to keep it secret, right? And you can keep the secret for as long as you can.
Well, yeah, as long as you can keep it secret. So, the example of Coca-Cola's recipe has been secret forever, but very often, depending on your business, it might be easy to infer what you're doing behind the scenes from the outcome.
So, what happens if the secret leaks?
Well, if you don't have patent protection, then you have no direct solution to that circumstance, apart from to go through, so if somebody's linked it by breaching your confidentiality, then that's an actionable thing. You can go to the courts and sue them for that. But whether you'll be able to undo the damage done to your business through that, because an individual can only give you so much money, and if it's critical to your business, it may not be possible to really return to where you started. So you just have to be very kind of careful to ensure if you're relying upon confidential.
But speaking of the idea itself or the secret itself, it's already, if it leaks, it's not enforceable anymore. I mean, anyone can do. For example, in the case of Coca-Cola, if someone finds out the formula, the law doesn't stop anyone from doing a clone of Coca-Cola company doing a clone. I mean, yeah, maybe they will not have as big a market as Coca-Cola because they have all this infrastructure and everything, but they will still have a clone of Coca-Cola.
It might be that if you could show that the reason why this company was able to make Coca-Cola copies using their recipes because of some breach of Coca-Cola's confidentiality, that a court would actually put some kind of injunction on them continuing to carry out that activity, which they were only able to do because of some wrong that they committed in the first place. But it becomes, it's quite, there's no clear-cut solution to that. Sorry, I think there was another question at the back.
Yeah, I have a general question maybe for both of you. So supposing that the patent has been awarded in a case where it is something implemented in software which is easy to copy, let's say, and it comes to the point where you have to decide whether to try to license it or to just sell outright the IP. So could you comment on if you try to go down the licensing route? I mean, it seems to me that, or conversely, if you sell it to a big company, they're like Apple or something, they have sort of the means and the will to defend the IP. But if QMI is licensing the patent to somebody, I mean, is that a credible threat to stop people from just copying it? I mean, would you really sue somebody for infringement? Because the point being that if it's just copied, then the value of the IP eventually would just, I think, disappear, right?
Well,
if it's not defended.
Yeah, I think that in some respects, you do want to have some credible threat behind it, but it doesn't necessarily have to be Queen Mary, it doesn't necessarily have to be the licensee. It could be the licensor who agreed that they would try and enforce these rights in such circumstances. Also, you know, of course, it costs a lot of money to take a case to court, and then it goes to the Court of Appeal, then it goes to the Supreme Court, and that happens. 99% of the time, you don't end up in that battle going that far. So you still have some leverage if you're able to go to a company, especially a significant company. It's not in their interests to directly infringe patents when they know they're infringing it. It doesn't do them any good. So, you know, large companies do tend to be reasonably respectful of smaller companies' IP, even if you think, well, the balance, if you went to court, is difficult.
I mean, if you think of something like a phone app or something like that, I mean, the people who would copy it are going to be obscure, like people in a back bedroom somewhere, and suddenly you've got 50 cloned versions of your patented thing.
Yeah, I mean, that's an issue. I mean, you probably speak more about the way you work that into your agreements and how that comes to your discussions.
Yeah, I mean, well, just to pick up on what you were saying about the license law. I mean, in agreements that we do, license agreements, the licensor will have rights to actually take people to court for infringement. And so if it is a big company, then it's a credible threat. But it's, you know, as both of you have said, it's a small company. You know, it's like any small company, isn't it? They're not going to be able to take a big player to court. And
is it commonly the case that a big company, you know, would license some minor thing, or would a big company always prefer if the total cost of buying something outright is relatively low, would they always try to buy it outright?
This depends.
I think it depends on the marketplace and where they are. I mean, so in the example of Spider.io, the reason Google, I think, were particularly interested in buying them rather than maybe licensing that technology or even acquiring just those patents was because they wanted those people. You know, it's not just about the patents. I don't want to overplay that. You know, and so it's the practical circumstances there. They've now got those people working for Google in-house, and that made their decision for them, I guess, about how they were to approach it. So sometimes it's not necessarily IP-related concerns that make that decision. It may be something more general about the business situation.
Any other questions? I've just got a quick question.
Okay.
Just to tie together Mark with the yourself.
Yeah.
I wonder whether you could comment on the pros and cons of patenting for SaaS-type cloud business models.
Well, I mean, it's a really interesting area, and the patent law, and law generally, is slow to move. And so it's designed for, here's a product in a box that gets sold individually, because here there's a transaction here for that box, and we can apply a license for that amount of money. It becomes more complicated, and you have to work harder to make it fit the kind of cloud model. It's certainly possible. And there are examples given, you know, if you want to license that technology out, that's a very easy way of doing it. You say, well, okay, well, we won't be providing that cloud service, and this other company will do so, but we'll license that technology, and they can do that on our behalf using the technology, or the market can improve generally. But it does make a difference, and it is important, I think, that you consider how you leverage your patent, why are you applying for a patent. There's no point applying for a patent if it doesn't fit your business model in some way. So it does work, it can work, but it is true that you've got to be a little bit careful, because it's a tool designed for the old world where there were physical products that went into shops and were sold. So it's a case of being aware of that complexity from the outset, that you can design the process so it works.
Last chance? If not, then you say thank you to Peter.